Good afternoon. A brief reminder, unless the court has put an order down otherwise, the oral arguments will be live streamed on the AOC site, and then the oral argument will be placed on the AOC YouTube site, so they'll be there for the public at large to view and watch as they choose. Call the first case, please.
Howard Jefferson Atkins versus Tennessee Department of Correction et al.
We'll hear from the appellant when you're ready.
May it please the court. Your Honor, if I may, I'd ask to reserve 2 minutes for rebuttal.
2 minutes?
Yes.
That'll be fine.
Yes. Your Honor, I represent the Department of Correction and Commissioner Strada, collectively the state, in this action that arises under the UAPA, the Uniform Administrative Procedures Act, initiated by the petitioner, Mr. Atkins, challenging the calculation of his sentence. The issue presented by the state in this appeal is whether sentence reduction credits lower the expiration date of the 60-year term for a life imprisonment sentence imposed on a first-degree murder conviction in two circumstances. One, for any offense committed between November 1st, 1989 and June 30th, 1995. And second, for a first-degree murder offense committed by a juvenile offender on or after July 1 of 1995. This is essentially a question of statutory construction. What the Chancery Court concluded is that the effective 60-year term for a life sentence, and for Mr. Atkins, he is a juvenile offender who receives the benefit of the Booker case to be treated as a pre-95 case.
And you're in agreement with defense counsel that the credits apply to the parole eligibility date. You're in disagreement as to the sentence expiration date.
That's correct. And we're also in agreement that the term is 60 years. We've not appealed. The only portion of the Chancery Court's judgment that we have appealed is application of the credits against the 60-year term, the expiration date.
It's a 60-year term with a 60%. Is that right?
Correct, which is how we get the 36 years calculated down.
As opposed to the original 60 years at 100%, which Booker overturned.
Correct. And this arises essentially from Brown. Well, I will say first, our view is that this case is governed by Tennessee Code Annotated 40-35-501 as construed by Brown and Booker, and that it is not governed by 41-21-236. So I'll address each of those in turn, but that is essentially our position. And under 40-35-501, as enacted in 1989, release eligibility for parole consideration is authorized after 60% of 60 years, so 36 years. There's no provision for applying sentence reduction credits. In 1993, that was slightly amended to require a mandatory minimum confinement of 25 years. And I would note the court also has before it, being submitted today on briefs, two related cases that have been consolidated for purpose of submission. Those are both adult offenders that fall under the pre-93 statute. I don't think the result is any different, but I just wanted to clarify those are under the pre-95. Mr. Atkins falls under the post-93, pre-95, because that is the remedy provided for in Booker. The statute makes no express provision for application of sentence reduction credits. What Brown clarified, the Supreme Court's opinion in Brown clarified that the life sentence for a 89 to 95 offense is a 60-year term. And then in Booker, the issue presented was by someone similarly situated to Mr. Atkins, a juvenile first-degree murder offender. It was his direct appeal of his conviction. And the majority of the court concluded that applying the post-95 law, the mandatory 51 to 60-year term, in his case, offended the Eighth Amendment. And the parties there agreed that the remedy would be to revive the repealed pre-95 law and apply it. So that's how the juvenile offenders fit under that. But throughout that opinion, looking at, it's a lengthy opinion, it's actually three opinions, lengthy decision, and in each of those instances, the court is very clear. First of all, when it discusses the post-95 law, it says it's a 60-year term, sentence reduction credits apply, but they are limited to lowering the sentence to a mandatory 51-year sentence. And there is no mention about parole or release eligibility consideration. That's because there is none. And everyone agrees with that. I don't think there's any dispute about what the post-95 statute is. Likewise, in all three opinions, when there is discussion of the pre-95 law, and that was particularly pertinent because it was the remedy for the Eighth Amendment violation. And in that context, the court says it is a 60-year sentence. It's a term of sentence of 60 years, but release is not guaranteed. However, to be more precise, it's a 60-year term. Parole eligibility occurs at 60% of 60 at 36 years. Accrued credits may lower that to a mandatory minimum of 25 years, but release is not guaranteed. That is to reach parole consideration. In fact, release is not guaranteed in any instance. What the result of the Chancery Court's judgment is that...
Under your theory, the release guarantee would be 51 years?
In this case, because it revives the repealed law. So the guarantee is to the end of the sentence. Now, I will say that raises an issue of might that separately... That has not been litigated in this case, and so I'm not comfortable speaking
So you're saying the
broadly
sentence expiration date isn't reduced to 51 years or 36 years?
No, it's 60 years.
Even though it's at 60%?
Well, it's 60% for parole consideration.
Right.
But not for the 60% does lower.
Okay. But for parole eligibility only? Correct. And with credits, it can go down to 25?
It could go down to 25. It can't go below 25 even if there are credits.
But that's parole eligibility only, and there's no assurance of being released?
Correct. And the only reasonable reading of those opinions is that's what the Supreme Court was saying when it construed what the pre-95 law is. Now, the petitioner's position on that is that application of credits is governed by 4121-236, that it simply was not presented by the case. And I respectfully disagree because the very issue presented to the court was not only what the term of the sentence is, that it's 60 years, the court had already said that in Brown, but it's also how that sentence is executed. And that involves knowing when there may be or may not be guaranteed release because of sentence expiration credits, or application of credits to the sentence expiration date, and also when it may be at least authorized through the consideration of parole. All three, particularly the plurality opinion and the concurring opinion, make clear that the release is not guaranteed. It is released for parole, and the sentence is 60 years. Our position is that looking to that construction of the statute, one must conclude that sentence reduction credits do not apply to lower the expiration date of a pre-95 sentence. Now that gets us to 4121-236, which the Chancery Court applied. And our position is that it does not govern this case for two alternative reasons. The first of those is looking to 4121-236B2. And that provides that reduction credit shall not affect release eligibility and sentence expiration dates in the same, shall affect release eligibility and sentence expiration dates in the same manner as time credits affected parole eligibility and sentence expiration dates prior to September 1, 1980. I've gone through in the brief at length, and I'm not going to repeat it all here in the limited time, but there was never, until the 95 Act, there was never application of credits to lower the sentence, to expire the sentence sooner in a life sentence context. Prior to 1998, it was a pure life sentence. It did not end until death. And in the 89 Act, what the General Assembly did is it retained this as a life sentence. Now, Brown and Booker have construed the language to mean it is a 60-year term, but it is still a life sentence. And that has to have legal significance. It's not merely a 60-year sentence. It's a life sentence treated as a 60-year term.
Doesn't one of the cases or one of the statutes say that we're supposed to apply the law that existed prior to 1980?
Yes, and that's this provision that says credits shall apply under this act, which was enacted in 85, the same as credits were applied in September 1, 1980. And the significance of that is in 1980, there was a change, and it was a hard reset, where the General Assembly enacted a new process for both good conduct sentence credits and prisoner performance sentence credits. And the latter of those became effective September 1, 1980. And so our position is that and that language is actually in the 80 Act, a version of it, is that's in 1980 set a hard reset. And that was continued with the 85 Act. And what it means is that this provision isn't substantively granting the ability to grant credits you didn't already have unless there is some other authority to provide for it. And what I mean by that is prior to 80 and then from 80 to 85, there were different ways of calculating like how many days you earned for a particular kind of credit in a month. After so many years or in different years you got different amounts. That was changed with the 85 Act to say it's 8 for good conduct and 8 for performance. And
up to 15 a month, but
correct.
No more than 8 for one and no more than 8 for the other.
I believe that, yes, Your Honor. And so what the significance of that is this wasn't, generally, this was not creating new credits. Now, there are two provisions in the 85 Act that did do that. It allowed, and I'll talk about these more fully in a moment, under C, where if you had a Class X felony sentence, you could waive into the new law. Or if you were sentenced under the 82 Reform Act, which otherwise did not have credit. So there was a substantive component in the Act that in certain circumstances, that would not have applied and did not apply to a life sentence, because a life sentence, someone convicted of a life sentence after the 85 Act up until the 89 Act, still was a pure life sentence and no credits were applied. Our position is that under the language of this provision, it simply does not govern a life sentence because credits were not authorized to reduce the expiration date of a life sentence as of September 1, 1980. And there is
when you say this provision, you're referring to B2?
Yes, or 41, yes, 4121-236 B2. And otherwise, because of that, we are governed by 4035-501. Now, the second argument, if the court disagrees on that point, the credits are still disallowed under 4121-236C1. And I'm getting close to my time, so I would just briefly point out, I slightly disagree with what I think, my read of the construction in the Chancery Court's order about what this means. My read of this is that regardless anything in 4035, no credits are authorized. But there are a host of provisions in 4035 that authorize changes to the general rule of providing credits. Our position is 4035-501. H1 is one of those. There are a host of others. The Supreme Court in the Davis case recognized that those other provisions exist and apply, but I think technically that is a conflict with C1. And in construing 4035-501H1 against 236C1, the specific provision there with detailed provisions about how credits are granted for parole eligibility and no mention at all for expiration dates, and that's confirmed by the court's construction and a fair reading of all three opinions together in the Booker case. With my time gone, I ask the court to, for the reasons stated and the reasons in our brief, that the court reverse the judgment of the Chancery Court as to the sentence expiration issue. Thank you.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
May it please the court, I'm David Esquivel with the Bass, Berry & Sims firm on behalf of the appellee, Howard Atkins. Your Honors, this case is much more straightforward than the appellants would have you believe, and as has been portrayed in oral argument and in briefing. This court should affirm the judgment of the Chancery Court because the court correctly held that the 1985 sentence reduction statute, which is generally applicable to parole and to expiration date, applies to the expiration date for life sentences prior to 1995. When the General Assembly wants to remove a sentence from eligibility for sentence reduction credits, it has done so expressly. The legislature has made no such exemption for life sentences imposed prior to 1995. This is a straightforward case of statutory interpretation that leads to only one reasonable conclusion. The expiration date for life sentences imposed under Tennessee Code 40-35-501H1 may be reduced by the sentence reduction credits authorized under Tennessee Code 41-21-236. Your Honors, I want to go straight to the heart of the dispute in this appeal, and that is the argument that my friend on behalf of the appellant makes on the interpretation of Tennessee Code 41-21-236B2. This is the provision that says that the sentence reduction credits that are part of this statute shall be imposed in the manner that time credits were imposed prior to September 1, 1980. The state's entire argument is that the General Assembly intended in this subsection to carve out life sentences from the sentence reduction statute, and that is wrong for many reasons. First, this is a definitional provision, not a substantive provision.
Which statute is the definition?
Subsection 236B2
Okay.
is, and my argument for the next several minutes will focus on this subsection because it is, in the briefing at least, the critical element that the state relies on. This is a definitional provision. The operative part of the sentence comes at the very beginning. Quote, "The allowances that can be awarded pursuant to this section shall be referred to as inmate sentence reduction credit." This provision establishes a different nomenclature from prior practice. It recognizes a change in terminology from PPSC, which we describe in our briefing as prisoner performance sentence credits, and good conduct credits, to a change to something called prisoner sentence reduction credits. Second, the state's interpretation of this provision proves too much. This provision is not limited to life sentences. It speaks to the entire legislation. Legislation that enacted in 1985 a dramatic overhaul of the sentence reduction credit system. The state's interpretation in this case of the General Assembly's instruction in subsection 236B is this: forget about every substantive change this comprehensive legislation makes. When you implement these sentence reduction credits, go back to August 31, 1980, and implement that sentence reduction regime instead. That is the consequence of the state's argument, and that interpretation makes no sense in the context of legislation that was comprehensive reform. That was the aim of the entire statutory scheme. It actually makes no sense for interpreting any statute because it is inconsistent with the way legislatures function in general. Legislatures do not enact comprehensive reform, then bury a clause in a definitional section that undoes the entire substance of the legislation. Third, even if this subsection is read as applying exclusively to life sentences, referring to the state of the law prior to September 1, 1980, would be a bizarre way for the legislature to articulate that exclusion of life sentences. As the state notes in its brief on page 15, the only significance of the date September 1, 1980 is that it is the effective date of prisoner performance sentence credits, which was part of the legislature's prior overhaul of sentence reduction credits in 1980. September 1, 1980 has no significance as it pertains to the imposition of life sentences. There is no reason for this court to infer from the legislature's use of this specific date that it has anything to do with carving out life sentences.
In other words, that it's not specific to life sentences, it applies to all.
That is correct. It is not specific. And if it does apply to all, then what the state says the legislature is doing in this provision is saying, we are enacting in 1985 comprehensive sentence reduction credit. We're instituting a new system, and it applies to everyone in the custody of the Department of Correction for every offense. However, under this 236B, what we want you to do when you implement this comprehensive reform, TDOC and judges, is to get into a time machine, go to August 31, 1980, and implement that regime. That is what the state is arguing today, is the function of that sentence, a provision that starts by saying, we the legislature, are going to create something new called inmate sentence reduction credits. Further, Your Honor,
Counsel,
yes.
I mean, in 1980, then what was a life sentence?
A life sentence in 1980 was a life sentence, and it was calculated for purposes of parole and expiration dates as 60 years. That was the years.
100% of 60 years.
In 1980, it was immediately following the Class X Felonies Act, which the parties briefed. In 1979, the legislature decided that for certain violent felonies, that there would no longer be the availability of good time credits. The time credits that were, the nomenclature at the time would apply to those felonies, so it'd be 100%. That's correct, Your Honor. If what the legislature meant to say, Your Honors, in subsection 236B, was that sentence reduction credits would not be used to reduce expiration dates on life sentences, they would have said that directly. They would not have made TDOC and the courts go through this elaborate exercise of asking us in 2025 to unearth the state of the law, quote, prior to September 1, 1980. In fact, we know this because the legislature has demonstrated on several occasions that when it wants to limit the application of the sentence reduction statute, it does so expressly, not in this convoluted way. For example, Tennessee Code Annotated 40-35-501I3, cited in our brief, expressly provides that child sexual predators, aggravated rapists, child rapists, multiple rapists must serve, quote, their entire sentences undiminished by any sentence reduction credits. And as recently as last year, 2024, the General Assembly amended the sentencing statute for first-degree murder and said expressly that sentence reduction credits, quote, shall not alter the sentence expiration date. That change is described in footnote 1 of the state's brief. So when the state and when the General Assembly decides we do not want the generally applicable sentence reduction credit statute to apply to parole or to expiration, it will expressly say so, and it has not expressly said so, either in the 1985 legislation or in subsection 501H1, the provision that now governs Mr. Atkins' sentence. Finally, on this point, Your Honor, the way time credits affect parole and expiration dates is not uniform prior to September 1, 1980. We can return to the Class X Felonies Act of 1979. It provides the most poignant example. The effective date of the Class X Felonies Act was September 1, 1979, and it eliminated good time credits entirely, as we've just discussed. It eliminated entirely for a number of felony offenses. But before September 1, 1979, good time credits were available for those felony offenses, which is what the legislature sought to change in the Class X Felonies Act of 1979. So returning to the provision that's at issue in this case, how is the court to apply the law, quote, prior to September 1, 1980, when the law in August 1980 is different than the law as it existed in September of 1979? The law is not uniform from 1980 going back to time immemorial. And so it makes no sense to construe this provision to mean that the court is to apply sentencing reduction credit laws as they existed prior to September 1, 1980, because in 1979 there was a dramatic change to that law. How would the court address the changes in laws over the decades of various sentence reduction programs since parole was first instituted in this state in 1913? The sum of all of this, Your Honor, and the answer here is that the state's interpretation of subsection 236B2 is incorrect. In 1985, the legislature created an entire framework around something called a sentence reduction credit. We go back to the basic building blocks. This thing is called sentence reduction credit. The essence of this statute in 1985, which is generally applicable to everyone in the custody of the Department of Correction, is to reduce sentences for good behavior and program participation. And the General Assembly did not upend that entire scheme through a clause buried within a definitional provision.
And it's your position that the sentence reduction credits applies to the sentence expiration date, not parole eligibility? Well, or both?
It would apply to both in
both.
this case, yes. My friend is correct that the sole point of disagreement from the Chancery Court's order is whether these expiration credits apply both to parole, which we agree applies to parole, and also to sentence expiration dates. And on that point, and for the reasons I've laid out, their brief has said the reason why you can take 236 out of and the sentence reduction credit statute out of the picture entirely is this subsection 236B2. Otherwise, I think the parties concede that this is a generally applicable statute and that the generally applicable statute applies to everyone in the custody of Department of Correction and applies both to parole and sentence expiration dates. And that is why this focus of the state is on this provision. I would like to make one note from the briefing that has not yet come up in argument, but I think is important so the court is under the proper impression of what the consequence of this decision. The state several times in its briefing has argued that a consequence of applying the sentence reduction credits to expiration dates for life sentences, that those sentences could be reduced to below 25 years or something, extremely, I think they said less than half of the sentence. That would be earlier than a prisoner could even be eligible for parole. And the answer to that is that the math is wrong. The earliest a prisoner can expire a life sentence is around 39 years, and a very quick explanation makes that clear. A prisoner can earn approximately 16 days of sentence reduction credits each month, which is slightly more than half a month, which means that for every 2 years served, a prisoner earning the maximum amount of credit can take slightly more than 1 year off of his sentence. So, a prisoner who has served 40 years and has earned and retained all the available sentence credits will have his 60-year sentence reduced by 20 years, which is a 40-year sentence. And that's why the calculation is around 39 years, accounting for the fact 16 days in a month is slightly greater than half. Now, that math is not pertinent to the statutory interpretation question, but I did not want the court to be left with the wrong understanding of the
How does that apply to the no less than 25 years? Is that the parole eligibility?
That is correct.
Okay.
What the legislature did there was to say if you apply sentence reduction credits to parole eligibility without any limitation, it would go below 25 years. So the legislature said apply sentence expiration credits, but minimum 25 years.
That's the floor.
That is the floor. Everyone is going to serve 25 years, and at 25 years you become eligible for parole. I would, in my remaining time.
I mean, are you saying that the sentence expiration date can never go lower than 25?
The sentence expiration date will never go lower than 39.
And 39,
That's correct.
That's it.
Under H1, that is right.
Parole would be 25.
Parole is
would be
25, and
yeah.
if you have bad behavior in prison and you get no sentence credits, you're eligible for parole at 36. And if you demonstrate bad behavior in prison and you get no credits, then you serve 60 years. That is how it functions. If I may, I know my time is up. There's one point that I wanted to address.
Sure.
If I may, very briefly.
ahead.
and that is the effect of the Booker and the Brown cases. But my friend in the Attorney General's office has spent a fair amount of time talking about Booker. The simple answer is that Booker is an Eighth Amendment case that was ruling on whether juveniles who are convicted, whether it violates the Eighth Amendment to subject them to a minimum 51-year term. The answer was no. There's no majority opinion, there's a plurality opinion, there's a concurrence, there's a dissent. Sentence reduction credits were nowhere on the radar screen in that case. Neither were they in Brown versus Jordan. To read into these sort of selected cherry-pick quotations from those cases is wrong, because those cases had absolutely nothing to do with sentence reduction credits. And the state is absolutely cherry-picking language from a case that does not raise that issue at all. And that's the simple answer as to why Brown versus Jordan and Booker have nothing to do with this case.
All right, one quick question. It's my understanding in subsequent proceedings, the sentence commencement date has been moved forward by a few months.
Yes, that's right. Mr. Atkins did not receive pre-trial jail time credit, which is different than the system we're talking about, that he should have received. The Department of Correction recognized that problem and has since corrected his sentence effective date. What this means is that it has moved up by 3 months. So Mr. Atkins actually will now be eligible for parole first week of September of this year.
And that's not in dispute.
That is a fact that we noted in our brief, just because it's important to Mr. Atkins what that date is, and he did not want that date to be incorrect in the record, and I totally understand why. Thank you, Your Honors.
All right, thank you. Hear from the appellant. We'll give you an extra minute on your rebuttal time, since we.
Thank you, Your Honor. I'd like to start where opposing counsel ended with regard to Booker and the notation that this was not on the radar. I think that represents a woeful misunderstanding of what the court was actually doing in Booker. It was assessing an Eighth Amendment violation in how Mr. Booker's sentence was being executed. That involved not just knowing when it ended, but also how credits could and would be earned, and whether, even though he would receive up to 9 years of credits from 60 years down to 51 years, that in and of itself, in the view of the majority, violated the Eighth Amendment. Didn't
Booker apply to the fact that the trial judges were not permitted to consider mitigating factors when first imposing the sentence?
That's correct, because it was an extension of the Miller case from the Supreme Court, where it was an automatic sentence by virtue of the conviction alone. And so by virtue of the conviction alone, the sentence would be 60 years with the potential down to a mandatory minimum of 51. But how that sentence was carried out was directly presented by the court. But more to the point now, once the majority of the court found that there was an Eighth Amendment violation, it had to determine what the remedy would be. And the parties agreed there. The remedy would be a revival of the repealed act. That's the pre-95 act that we are now discussing. It's also the same act that's at issue in the other two cases submitted to the court. So when the court is discussing what that sentence actually is, to determine if it is a viable remedy for the constitutional violation, it is absolutely on the court's radar what sentencing credits are and are not earned. That is a necessary component. And both the majority and the plurality note multiple times. This isn't cherry picking. This is about what the court actually said the sentence as executed actually is. That release is not guaranteed, that there is parole consideration between 25 and 36 years. As I understand the argument, and the judgment of the the Chancery Court, that this is sort of connecting a bunch of dots to get to the result, which is, it's a life sentence, but we know from Brown and Booker that is a 60-year term. And the argument essentially boils down to, since it's a 60-year term, it fits under the general statute. I've already addressed the 236B1 issue, and I rely on what I've said and the argument in the brief on that point. But even if you're outside of that, you still come into conflict with C1, because C1 purports to say nothing in 4035 can overturn the credits under this general rule. But we have a specific statute, again, that Booker applied making no provision whatsoever for sentence expiration credits. It's because of that language, and most importantly, the Supreme Court's construction of it, that dictates the result in this case. And it's for that reason that we challenge the application of sentence reduction credits in this case. Thank you, Your Honors.
Thank you. Of course, thanks to counsel for both sides. We appreciate your arguments this afternoon and your briefs on this matter.